In the previous video in this series, we discussed case studies that cast doubt on whether unwritten customs and usages of trade existed in American merchant communities at the turn of the 19th century. Yet, as the critics of these studies rightly noted, there have been many changes in the infrastructure of commerce over the past 100 years. Changes profound enough to make it worthwhile to explore whether unwritten usages might exist in more contemporary merchant communities. In this session, we will begin by looking at the best available contemporary evidence about the existence of usages. Although limited, it strongly echoes the findings of the historical studies of the medieval law merchant and the case studies of trade associations' efforts to codify their customs, all of which call into question whether any but the vaguest or most local sorts of usages actually existed. After looking at the evidence, we'll take a step back from the positive question of whether trade usages exist and briefly explore the normative question of whether, if they exist, they should be used by courts to resolve contract disputes. And we'll conclude by discussing how the evidence presented in this series might help to usefully reorient the focus of future research in the area of private ordering. So let's begin by turning to the evidence. The first study was conducted in the late 1990s. It was a structured survey exploring the existence and content of unwritten usages in the grain and feed trade in and around Amarillo, Texas, a time and a place where all of the preconditions conducive to the emergence of usages were also present. The firm surveyed all had a place of business within 500 miles of Amarillo. A large proportion of the contracting relationships were long-standing and repeat, and the transactions were mostly standard contracts for the actual delivery of standardized commodities. Yet, like the older historical case studies, this study too found that transactors simply did not agree on the content of usages or the meaning of words. Let's look at a few examples. Transactors agreed there was a usage that a price adjustment was often an appropriate response to the delivery of non-conforming goods, yet they did not agree about how the amount of the adjustment was to be determined. Some said it should be negotiated. Others insisted it should be done on the basis of a regional price list, while still others staunchly maintained that it was always based on a local price list. Similarly, while transactors agreed there was a usage that a grace period for late payment was appropriate, they could not agree on how long the grace period should be. Follow-up probes revealed that their view of the appropriate length of time was correlated with specific characteristics of the contracting relationship and not any general principles that the transactors thought should prevail across all deals. There was also widespread disagreement about the meaning of particular words and terms, even those, like FOB, that were defined in written contracts, trading rules, and laws. Indeed, they could not even agree on what the acronym meant. The survey also asked transactors whether there were unwritten usages and practices they expected their trading partners to follow. 72% answered yes. There were usages they expected their trading partners to follow. But when merchants were then asked to give a concrete example of such a usage, not a single transactor was able to produce one. Eventually, after additional question probes were used, 65% gave an example. But among their answers, half were practices that were codified in written industry rules, and most of the others were just old boy rules of thumb, like follow the golden rule or my word is my bond. One common reaction to the results of this study and to the case studies presented in the previous video was that they must be wrong. Why? Well, usages were said to be proven in court every single day. To explore this possibility, I undertook another study, one that looked at all of the reported trade usage cases in the United States from 1970 to 2007, and the records in many of them. What I found was that the evidence that was introduced to prove the existence and content of usages was exceptionally, and I mean exceptionally thin. It did not even come close to either the type or the quantum of evidence that proponents of courts looking to trade usages assume will be introduced to prove them. These theorists posit that usages will be proven by some objective evidence of a pattern of behavior in the relevant trade, such as expert testimony and evidence about statistical regularities. Similarly, the leading commercial law treatise notes that to prove a usage, a party must usually call an expert, a position that's echoed by the most prominent practice manuals. Yet despite this consensus, the evidence that was actually introduced was quite different. Expert testimony was introduced in far less than 22% of the cases. Written evidence of usages was admitted in only 6% of the cases. And in more than half of the cases in which a usage was found by the court to exist, the only, and I mean the only evidence of usage presented was the testimony of a party or their employees, which usually went like this: yes, a usage exists. Even more striking, there was not a single case in which data was introduced to establish how frequently or widely the usage was observed. Indeed, across all of the reported cases, I was not able to identify a single alleged usage whose existence had in fact been demonstrated in the manner or to the extent assumed by scholars, treatise writers, practical manuals, or the code's drafter himself. In sum, the best empirical evidence suggests that sale-related usages of trade did not exist in the Middle Ages, did not exist in American merchant communities at the turn of the century, and do not exist in these communities today. Despite this, the notion that they do retains its hold on the imagination of law reformers and commercial law theorists alike. Indeed, they are so wedded to this notion that usages exist that they have refused to explore the question empirically, explaining that they are completely content to rely solely on what they describe as the extremely strong pre-theoretical empirical presumption that widespread, identifiable, and effective commercial practices do exist. Given the tenacity of this belief, it's useful from a pragmatic perspective to explore whether, from an economic point of view, it would be normatively desirable for courts to look to usages of trade, even if they actually did exist. In recent years, a small group of scholars known as the neo-formalists had put forth a variety of reasons, some practical, others conceptual, that usages should not be looked to by courts deciding contract disputes. Among the practical concerns these scholars identified in the United States context are the high cost of determining the content of usages, the ease with which usage-based arguments can be used to defeat summary judgment, the extra drafting costs incurred by the parties as they attempt to fortify their contracts against usage-based interpretation, the risks that parties will engage in strategic behavior with respect to industry terms of art, and the uncertainty that these usage-related inquiries introduced. In addition, there is a more basic and fundamental reason that incorporating usages into contracts is undesirable from an economic point of view. Namely, that in practice, it prevents transactors from using their preferred mix of legally enforceable contract provisions, extra-legal agreements, and ad hoc workaday adjustments to govern their contracting relationship. It does this by transforming extra-legal agreements and workaday adjustments into legally enforceable usages, and thereby destroys the unique value they create. Because legal and extra-legal obligations are often differentially well suited to governing particular aspects of commercial agreement, for any of a number of reasons, including the fact that they condition on different types of information, this consideration, even standing alone, suggests that the incorporation of trade usage into commercial agreements may be quite costly to business transactors, even if trade usages exist, which is the evidence presented in this and the previous videos suggest they manifestly do not. Now, in closing, let's return briefly to where we began. That is with the medieval law merchant. The evidence presented here, together with the findings of historians, suggests that it's time to put the idea of the law merchant, whether medieval, mid-century, or contemporary, to bed, once and for all, in an effort to save both legal reformers and institutional economists from what Emily Cadence calls the tyranny of a construct that has distracted scholarly attention from focusing on the types of institutions and social network structures that actually did play a role in supporting trade in the Middle Ages, both in Europe and among the Maghrebi Jewish merchants who traded across the Islamic Mediterranean. Institutions and network structures that, properly understood, can point the way towards better supporting exchange, both in developing countries and in countries with well-functioning legal systems.